This Crawford rule does not apply to non-hearsay statements. Yeah, out-of-court statements that are not hearsay because they are not assertions, not offered for the truth, or are attributable to the defendant. Yeah. Now, I'm sure when the prosecuting attorney's office, yeah, did decide to criminal complaint me, statements by a crime victim made to a prosecuting attorney in the course of seeking my incarceration. Yeah. Statements by a non-victim of any domestic violence accusing me of domestic violence in Britain, Washington. Um, all of these statements that are involved in the criminal complaint process, yeah. Do you know if it's actually Heidi Budnick that was saying that, or did somebody else take it upon themselves to make all these accusatory statements that are not admissible in court? Now, I'm the one that's going to the mental institution, okay? Yeah. But I've never read any signed statement where there's any liability to any person, yes, to obligate me to go to court for a year and a half, yes, so that I have to go to a cell hearing when I know that the police department does know I was not in that city on that day. Now you would say, well, why not I just call the police? I have spoke to Appleton Apples, and Mr. Johnson, as big as he is, pooch. It seems that the police and the sheriff's departments have been compensated to cover up the crime of admitting hearsay statements about myself when they know the statements are untrue. Yes, they're not truthful. Oops, they are not true and correct, as in they know it's a lie. Oh, now, just thinking about it, if the police don't want me to contact the FBI because they won't allow me to use their cell phone, shoot, and they're committing a regular old Matthew Shepard because I'm thinking that nothing I say will ever be admitted as being true and correct. Yes. Now, as the defendant multiple times in multiple court hearings where I didn't cause any trauma, which you would have thought that you would have protected my rights, but no. As a court, you don't feel any compulsion to do that. Now, let's say you're in the, what's it called again? The judge advocate court. Yeah. I found this interesting that there are certain obligations to the Sixth Amendment. Yeah. Criminal prosecutions. Isn't this a criminal prosecution? Yeah. Scientific confrontation clause generally satisfied when defense is given a full and fair opportunity to probe and expose these infirmities through cross-examination. Yeah. Could be some sort of psychosis or some other type of delusion on the part of the petitioner to not sign the protection order. Now, I know you say she's not crazy, she's the victim, and it couldn't be child abduction. You're never wrong as a police department. Now, let me see here. Introduction. Oh, hang on. I know. Oh, it's tab M. Yes, on page 400 and 901. Now, there's the appeals process. They're going to say, well, he's crazy. We don't have to listen to him. Yeah. You're crazy. Yeah. And larceny of government co-conspirators. I thought there was something in here about the military being liable for the knowledge of the conspiracy in this county, Jefferson County, yeah, or Washington State, yeah. Now, just a second here. Limitations on cross-examination, yeah. Uh, accused could forfeit his hearsay rights on the MRE through wrongdoing by acquiesce, yeah. Ability to remember. Oops. Nobody remembers I was in Port Angeles this whole time. Yeah. Limits to face-to-face confrontation, remote and screen testimony. Child victim will be traumatized by the presence of the accused. Yes. Reliability, physical cross-examination. Now, exactly how much liability does the military have for the knowledge of this conspiracy? Let's say I went to suing those in the Department of Defense. Can witnesses who are not the victims use remote procedures? Somewhat in Maryland versus Craig focuses on the court's approval of state interest. The state interest in protecting child witnesses from trauma of testifying on child abuse case. Now, this is a child abuse minors named? Yeah. Now, United States versus McDonald, Charlotte Precinct report for court martial government's only was notified in the Middle East. I just wanted to know how much liability the Judge Advocate Corps has of the knowledge of violating the rules of criminal procedure. Coach. I thought they had to use the same rules, but I could be wrong. Now, there was, and was really what I was looking for. Hang on just a second here. Lab reports, random urinalysis, casual remarks, statements by family and friends, confrontation clause, military cases. Now I'm just, it seems, what's this here? Oh, 2 ways to analyze Crawford. The National District is a statement testimonial. Is my witness available? Uh, oh, well, there's quite a little schematic there on the confrontational clause analysis chart. Yes. Now, you could maybe use it. Now in tab N, this is interesting. Yeah. Rulings on evidence, limited admissibility, remainder, relevant evidence. How relevant, number 4? Yes. Rule number 401. How relevant is the evidence that I wasn't in Brennan, Washington when being tried for violating the restraint provisions of a protection order that the allegation is it happened in Brennan, Washington? Is that relevant evidence? Chief of Police of Sequim, Port Angeles, Port Townsend, or any police department? Character evidence. Where was I? Used at the senior center. Does that apply to my character if I am an associate member of the senior center? A lot of people say, oh, that's good. A lot of the senior citizens that, you know, quite often, rules applicable, rules of privilege, rules relaxed. Yes, yes. Ruling on evidence. This rule imposes significant responsibility on counsel to raise and preserve evidentiary questions for review. Yeah. Now, I just wanted to look at the evidence, okay? Uh, Objections to the evidence? Does anybody object to me admitting the evidence that I was making videos on the morning of June 16th of 2017? Or the possible million emails that I sent from that time until this time? Coach. Now, preserving my right to appeal the court decision, the cell hearing? Yes, because I have to go to court. Rules of evidence. Yeah. Who was it that witnessed the United States? Oops. It looks like CID is personally liable for their knowledge. Now, as much as the Army dislikes me suing them, coach, all enlisted volunteer Army, it seemed that there's quite a problem with the black market in the Army. Yeah. If you're in the Army, could you go through and just, we have a barcode system in schools. Yes. Why don't we just put a little sticker on everything the Army owns, and if you're in uniform, okay, just write Paul's name on every item owned in the United States Army. Yes, because you could be in the Army without any actual equipment, which I could sell it at surplus. Yes. You could be in the Army without any tanks at all. You could just go out there and fist fight it. Yeah. You could be in the Army without any Army bases, without any buildings. Without any paper, without any pencils, without any pens, without any desks. Like you could be in the Army in your own personal clothing. Yes. Now, I'm not telling the Army to not, yes, continue to enlist personnel known as soldiers. But let's say you found out that you didn't actually have any equipment at all, because I can actually sue the Criminal Investigative Division of the United States Army for having knowledge that the rules of evidence are the same in the Army as they are in civilian affairs. Yes. Now, it's not that I take your pay away. You're welcome to have that, except for maybe a sign-on bonus. But I would take every uniform. Yeah, you can wear your street clothes. I'd take every uniform of every person in the Navy. I'd surplus it. And you can just go to work in a non existent base with non existent equipment and non existent uniform.